이러고
이게 시작되는 거야.
아니 되는데 만약에 이게 안 나오고 거기서 이렇게 되면 계속 있으면 어떻게 돼요?
아니, 빨간 버튼 누르시면 진짜 되는 건데요.
It was an eminent case when it discussed the federal system in the United States, which analyzed in detail about the necessary and proper clause called McLaw versus Miller. It was decided in 1890 and provided a foundational guideline about the federal system in the United States. And now we turn to the commerce power about the federal government. It is also one area of intertwining nature between the federal and state governments. We see an area development about the court position. The federal power with respect to regulation of commerce is derived from the Commerce Clause. It grants Congress the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. Commerce Clause, of course, must be read in conjunction with the necessary and proper clause. It is one of important clause when we debate the scope of federal government. A federal contract does not need to obtain a license from the state to do business in order to construct facilities at an Air Force base, pursuant to the government contract. It is one of the case applied in view of the Commerce Clause. And we may think about the interstate collaboration, the interstate compacts. Article 1, Section 10 permits creation of compacts between states with the consent of Congress. Such devices are especially useful in dealing with regional problems, crime, pollution, conservation, and transportation, and our favorite means of settling disputes. Some compacts may vary even without congressional consent. Therefore, there could be found a scope of a constitutional authorization in terms of a interstate collaboration. The interstate compact would be normally honored in the United States Supreme Court. And one other principle we have to keep in mind from class is the separation of powers. This doctrine is very effective across many of a federalism jurisdiction. The first concern should be about the policy-making conflict between legislative powers and executive authority. The Constitution provides for separation of powers. There are many gray areas in which responsibilities are shared to some extent. For example, the President may establish the national agenda and propose legislation, but only Congress can enact law. Yet, the executive power may also include some legislative authority. The Constitution in Article 2, Section 1 vests the whole executive power of the United States to President. It could not be questioned that the President is the central organ in terms of implementation of the public policy, and it was plainly provided in Article 2, Section 1. Then we would be curious about the scope of a potential of a legislative powers about presidents. Separation of powers doctrine requires that the legislative power be vested in Congress. Nevertheless, the Constitution grants the President limited legislative powers. The first will be the power to propose legislation. Although there would not be an explicit provision about the power to propose legislation in the United States, we could give you some of clues about the power to propose legislation. It is distinct from the case of a Korean constitution. In addition, Congress may delegate some of its legislative power to the President, such as the Securities and Exchange Commission, as long as the delegation is pursuant to reasonably definite standards. And the President also has the veto power. Article 1, Section 7 gives the President the power to veto any act of Congress. However, Congress may override a presidential veto by 2/3 vote of both houses. This is also recognized in the Korean Constitution. And most representative case about the legislative power of the United States President would be the case called Young's Township and Tube Company versus Sawyer. It was decided in 1952. And the case arose from the context of Korean War. It was in some sense a national crisis involving a war situation. And the President exercised some of his legislative power to control the industry, indispensable to carry the war mission. But it mattered with the private property, and a key liberty interest was at stake. Therefore, some sort of articulation should be rendered between the legislative authority and the President of the United States. the Supreme Court of the United States struck down the decision of lower court and invalidated presidential action. We can see the great fact about this case in the printout. The steelworkers, after prolonged negotiations, went on a nationwide strike during the Korean War. Citing the serious national interest in steel production, President Truman ordered the Soviet Commerce Secretary to see the steel mills and keep them running. Youngstownship and Tew, who were the plaintiff in this case, challenged the seizure as unconstitutional and unauthorized by Congress. Congress had already passed the tax tariff, giving foreign authority to seek an injunction against such strike, but it rejected an amendment to permit government seizures to avoid serious shutdown. The district court issued a preliminary injunction against it, which was stayed by the Court of Appeals. The Supreme Court granted censure. What is the problem? Let's raise the issue. May the President, acting in the aggregate of his constitutional powers, exercise the lawmaking power independent of Congress in order to protect serious national interests? The court rejected this argument. The court said negative. The judgment of this court is a fault. Sorry that I misread the decision of a lower court. The Supreme Court decision went affirmatively or in favor of the judgment of this court. And we have summary of a court opinions. The present power to issue the order must stem either from an act of Congress or from the Constitution itself. Congress clearly gave no such power. In fact, it specifically rejected the means used by them. President authority of commander-in-chief does not warrant the sea, as it is too far removed from the theater of war. The theater of war is remote, which was carried in Korean Peninsula, long way across the Pacific Ocean. The general executive powers are inapplicable since there is no relevant law to execute. The order does not direct the congressional policy be executed in a manner prescribed by Congress, but that a presidential policy be executed in a manner prescribed by the President. Such presidential usurpation of the lawmaking power is unauthorized and invalid. But we are not sure if the court took this position if the war breaks in this contemporary time. Because if the word remote construed in geographical aspect actually would not be so remote, because we have high-speed air fighters or air carriers. Could it be remote in terms of this called logic. Think about it later after class. There was current opinion in this case from Justice Jackson. A president's actions may fall into a category where Congress has authorized him to act, where Congress has neither granted nor denied him authority, or where his actions are incompatible with the will of Congress. In the last case, the president must rely on his constitutional powers, minus the powers of Congress, and his claim to power in such circumstances must be scrutinized with caution. The president's actions in seizing the steel mills fall into this last category. None of the arguments advanced by the Solicitor General in support of power of seizure by the requisite script. But we also have a dissenting opinion from Justice Vinson and Justice Newman. The President has a duty to execute legislative programs supporting the armed forces in Korea. President action was an effective means of performing his duty and was clearly temporary and subject to congressional direction. So there would be some myriad of different ways between the President and Congress surrounding a war-making authority. And also, the nature of powers separated in terms of legislative and executive. It will overlap in some cases. And we now turn to the Commerce power with the cases posed in New Deal time period. Soon after President Roosevelt took office, a flood of new legislation was passed, which attempted to deal with the depression, national economic disaster. Much of this legislation was based on the Commerce Clause. But the position of the Supreme Court could be rightly said very conservative and in favor of a liberal stance. This conservative judiciary rejected the New Deal programs in many cases. Which means a very restrictive stance about the interstate commerce clause. In the fourth test of New Deal Commerce Clause legislation, the Supreme Court invalidated the Railroad Retirement Act of 1934. The act established a compulsory retirement and pension plan for all carriers subject to the Interstate Commerce Act. The argument was that such a plan was necessary to the morale of the workers, and that this morale affected efficiency, which in turn affected interstate commerce. The court held that the relationship of such legislation to interstate commerce was too remote. The court theory about interstate commerce was started with the geographical considerations, whether it is geographically a matter of interstate commerce when they are posed by the legislation about this sort of problem. Later, the theory was developed an indirect effect. The court used the word indirect effect when they like to strike down the enactment at power. In Chattel Poultry Corporation versus United States, 1935, court ruled that Congress does not have power to extend the regulation of interstate commerce to interstate activity that have only an indirect effect on interstate commerce. Plaintiffs in Chattel attacked the National Industrial Recovery Act of 1933, which promulgated a cause of fair competition for trade and industry, the violation of which were misdemeanors. The court held the act unconstitutional because plaintiffs' activity, the sale of poultry only to local retailers, was not in the current of commerce, because the wages and hours of plaintiffs' employees would only indirectly affect price structure of the industry. The act was due to expire by its own terms about a month after the opinion was issued. And one other case around this time would be a Carter versus the Carter Court Conference, decided in 1936. This case was disputed around federal power of production of goods, where the three for fact patents, let's see, Carter Prison and a stockholder in Carter Coal Company was the defendant in this case, brought an action to enjoin D from paying a tax assessed against it under the bituminous Coal Conservation Act. That act sought to regulate hours and wages in coal mines and impose a tax on the sale price or fair market value of all coal mined by any producer who did not comply with the regulation. The government considered tax was a penalty under the trial rate tax case, and the regular aspects were within the commerce power. So the government attorney argued in this direction. A federal district court found in favor of D, and he appealed. So we can find an issue in this case. Let's see, does Congress have the power under the Commerce Clause to regulate the hours, wages, and other employment conditions of the national coal industry? The court held no, lower court reversed. So you can see it was an era of a tremor about a transitory state from purely a liberalist scheme of aid, say to some form of a modern welfare modality. And initially, the court was reluctant to follow the updated aid program executed by President Roosevelt, where they gives the court opinion about relations between employer and employer have only an indirect effect on interstate commerce, and so are not spheres of congressional rights regulation. Commerce has been defined for the purpose of the Commerce Clause, as the equivalent of in the course of a purpose of trade. It should be a trade in its nature, according to the court position. It should not be a matter of production within the state. So the chance to be struck down with inclusive the Congressional Act focused on a pure intra-state production activity. The employment of men and the fixing of their wages, hours of labor, and working conditions constitute intercourse for purpose of production, not of trade. Everything that moves in interstate commerce is local origin. The local character of mining, manufacturing, or agriculture does not change merely because the products of those processes move in interstate commerce. The relations between employee and employed are local relations and should be subject only to local regulation. Of course, the production of every commodity intended for interstate sale and transportation has an effect upon interstate commerce. However, activities relating to production can be said to have only an indirect effect on commerce. The distinction between a direct and indirect effect is not upon the magnitude of either the cause or the effect, but entirely upon the manner in which the effect has been brought about. Congress can regulate only those things that have direct effect on commerce. Mining is not one of them. You also have to bear in mind that the federal power is enumerated in its nature within the United States Constitution. Unlike the federal government, the powers pertinent to the state management would be preserved in its origin within the state government. It was plainly expressed in the language of the 10th Amendment of the United States Constitution. There was dissenting opinion from Justice Cardozo that said that mining, agriculture, and manufacturing are not interstate commerce considered by themselves, yet their relation to commerce may be such that for the protection of the one, there is need to regulate the other. The language of direct, indirect relation to commerce must not be taken too literally, since past cases do not show literal application of such language. It appears that proximity or remoteness of activities to commerce is a more logical way to approach the subject. For facing this negative response from the Supreme Court, President Roosevelt embraced a court packing plan to multiply the number of the United States Supreme Court justices. That means that the Supreme Court could be weakened and would be restricted, but to follow the initiative of an executive also. But his plan was not realized. President Roosevelt felt that the court was judging public policy of the New Deal rather than its constitutionality. He proposed legislation to allow him to appoint an ex-justice for every justice over 70 years old who did not resign. The legislation never passed. The some observers felt it prompted a change in the course analysis of New Deal legislation. As the role of Supreme Court justice in the United States is very dispositive about critical national agenda. There will be some cases we can encounter to analyze in personal and historical context. Recently there was some law regard about the Supreme Court Justice rankings from some of interdisciplinary legal literature, and which is seen as rare, like most of user dealings in legal research. And we have some change since 1937, which could be recontextualized involving the industry complex power. The court showed a heavy difference to the congressional authority. The court coined a term, a affectation doctrine. Since 1937, the court has abandoned geographical and direct versus indirect concepts. The court's position now is Congress has the power to regulate any activity, whether it be interstate or interstate in nature, as long as it has any appreciable effect, whatever on interstate commerce. This is called the affectation doctrine. The doctrine was first applied to the case involving labor relations affecting commerce. It was decided in 1937, NNRB versus Jones and Livingston Corporation. In this case, the National Labor Relations Act of 1935 provided for union-employer collective bargaining in all industries affecting interstate commerce. Jones and Lawrence Steel Corporation, who is the defendant in this case, the steel manufacturer, claimed Congress had no power to regulate its industry. It was an integrated company owning subsidiaries all over the United States. 75% of the product of the plant in question was shipped out of state, and it got raw materials from out of state. The NNRB order did comply with the Act's provisions, but the Court of Appeals refused to grant judicial enforcement of Pierce order because it exceeded federal power. The Supreme Court grants is so short. As you see, the federal government frequently invoke this the interstate commerce clause as a basis of the exercise of a federal power. But you have to keep in mind that there would be no federal police power in the scheme of the United States Constitution. Therefore, the issue should be, make Congress regulate or manufacture if the manufacturer's activity significantly affects interstate commerce. The court said yes, judgment reversed. We have an essence of court opinion. 10, affecting commerce means burdening or obstructing commerce or the free flow of commerce, or having led or tending to lead to a labor dispute, burdening or obstructing commerce or the free flow of commerce. Labor strike at this point would conceivably cripple the entire interstate operation of commerce. Thus, interstate commerce was affected, and Congress may regulate this activity. We also have dissenting opinion in this case. The case arose from the discharge of 10 men for union activity out of 10,000 men who work at this factory. Any effect this charge has on interstate commerce is highly indirect and remote. The dissenting opinion pointed to a practical dilemma or odd consequences when the act was conformed as constitution. We have reviewed the federal power about the interstate commerce clause and the war-making authority and other kind of debates between nature powers. One significant achievement about the war power would be the war power resolution made in 1973. Congress adopted a joint resolution called the War Powers Resolution, which spelled out the president's authority to use the armed forces. If the president uses the armed forces in foreign nations under specified conditions without a congressional declaration of war, he must formally report to Congress. The Congress provided the power to declare war should be vested within the Congress. And the Florida, the commander-in-chief in warfare, would fall within the President of the United States, President commander-in-chief. The war situation would normally be imminent or critical in time. Therefore, the president may initiate an initial military action. That would be a constitutional. He was obligated to report whatever about the theater war to the congressional authority. So in the absence of any congressional action, forces generally must be removed within 6 days. And we have reviewed some other powers vested within the President of the United States, the executive branch of the United States. First, the President of the United States has an appointment power in Article 2, Section 2. The section indicates the President, with the consent of the Senate, may appoint ambassadors, consult justices of the Supreme Court, and all other officers of the United States, whose appointments are not otherwise provided for. Therefore, the President has a duty about the appointment of a critical federal officers. The scope was defined. definitively stated in a constitution. And further, Congress may vest power to appoint inferior officers in the present law. There would be two sets of officers when we talk about the appointment power. And it was a critical issue normally raised around this session. In Berkeley versus Farrell, the court relied upon this provision in holding that the composition of Federal Election Commission established by Federal Election Campaign Act was unconstitutional because enforcement powers of commissioners who were appointed by Congress co-held that they exercised executive powers, thus making them officers of the United States, whose appointment was subject to appointment clause. Therefore, the commission should be approved by the Senate and be nominated by the President according to the constitutional provision and a relevant statute. And the President has the removal power. Unlike the appointment power, the President is generally free to exercise this removal power. He is able to remove without the Senate approval, like the appointment process. But there will be some court statement about judges and other officers performing judicial functions. Those officers would be crucially related with the idea of judicial independence, which means more heightened extent of a job security should be given. The President cannot remove either Supreme Court or lower court judges. Article 3, Section 1 provides they shall remain in office during good and behavior. Therefore, the judges of a federal court could be on a lifetime tenure normally, practically. What are those about executive officers? In Myers versus United States, the Supreme Court held invalid the statute which said that the President could not remove postmasters without Senate approval. The court stated that the President could remove all executive appointees at will, even though the appointments originally required the advice and consent of the Senate. As I said, the court imposed some limitation on Myers. For example, there will be some controversy about a cause for removing. Humphreys executed versus United States, decided in 1935, limited Myers in that it said the officers of administrative bodies created by Congress, where the statute specifies the term and cause for removal, may be removed by the President only for those posts that have been specified. And we have cases about officers performing judicial function. These persons are not a judges in terms of Article 3 of the United States Constitution. They are not Article 3 calls judges. And may be created for the needs of our commission informed of a statute. Many administrative tribunals in the United States will be formed in this way. We have to bear in mind there will be a separate constitutional approach about the judgment of Article 3 and officers performing judicial functions based on Article 1 of the United States Constitution. In some cases, the court so very narrowly about the race issues and strictly distinguished from the Article 3 court judges. But when we talk about the removal power and duties, then the court normally has a common approach in those two groups. Weiner versus United States, decided in 1954, further limited the private removal power. The War Claims Commission, established by Act of Congress, mentioned nothing about causes for removal. The Supreme Court differentiated between officials who were part of the executive establishment and those who should be independent of the president's removal power. The court held that it was unconstitutional to remove a member of the commission without cause, as the commission exercised judicial function. And we have a case about presidential papers that it was introduced in the previous class. I legitimately skipped the case. You can see in page I have no page indication on this printout. The case was titled Military versus Foreign. It is a very famous case dealing with the treaty case. We have a case concerning external affairs, and the court struck down the state enactment of repugnant to the treaty included between the United States and Canada. As you see, an international treaty, one form of a federal laws in the framework of the United States Constitution. Therefore, it entertains a federal supremacy over the laws of each state. As a fact, the Migratory Bird Treaty Act of 1918 implemented a treaty between the United States and Canada and prohibited the killing or interference with migratory birds except as permitted by regulations made by the Secretary of Agriculture. Missouri, as the state of the United States and a plaintiff in this case, brought suit in equity to enjoin foreign, a United States game warden, the branch of federal government, from enforcing the act. He claims the act unconstitutionally interferes with state rights and an earlier similar act of Congress, not in pursuance to treaty, was held invalid. So this court dismissed the action. He appealed. Therefore, we can see the issue with to this case. May an act of Congress implementing a United States trade regulations would be unconstitutional if acts to the law. The court favored the case of a federal government, and the court also gave a no to critical law of federal government about external affairs. But we have to caution in some sense that the federal government may probably dispose to expand unconstitutionally the ground of federal powers. They would prefer treaty relations if they cannot easily find the constitutional grounds in domestic context. The court held yes, judgment afforded. The 10th Amendment is irrelevant since the power to make treaties is delegated express further. If the treaty is valid, the statute is equal to being necessary and proper. Those two set of norms will go the same. The treaty doesn't permit any prohibiting words or found in the Constitution and is presumed valid. The important national interest here can be protected only by national action and considered with that of another nation. The joint effort is possible only through a treaty, since there is no specific constitutional restriction and the national interest requires it. The treaty requires it, so-called treaty, and therefore its implement statutes are valid. The state's interest was sufficient to justify regulation in the absence of federal regulation as to transitory to grant specific national regulation, especially when the national action arises from exercise of treaty power. The case implies that the treaty can confer upon Congress powers in addition to those granted in Article 1, subject to specific constitutional prohibition. In another case, the Jeffrey versus Riggs decided in 1890 noted that treaty power may extend only to proper subjects of negotiation between a government and the governments of other nations. Therefore, we can see the military code would be very generous in the extent of an application surrounding the treaty argument.